Assalamualaikum sir, my name is AFIFAH binti Jaafar. My ID number is 2020139359. My partner group is ZATIL Ishma. I'm the first one to present about this assignment. Okay, first introduction. Employment of women. Women employees are protected at work. As stated in Part 7, Employment of Women in the Employment Act 1955. This act is made to make sure the right of the female employees are being protected. Not only by that, as this act is made especially for the female employees, this act are made special for the protection of the female employees at workplace. The act does not require equal pay for equal work, nor does it outlaw the discrimination faced by the female employees. The provisions stated in the Act are relating to women mostly concern working hour and maternity benefit. Each local authority has a councillor or councillors appointed by the state government. The councillors act as the legislative branch of the city governments, which is also believed to be a policy-making body. Among the characteristics of the councillor or councillors is first, the councillors or council member live in the local authorities area itself. Second, the council member or councillor must have experience and knowledge in managing a local authority. Third is that councillors or councillors need to have a background in areas of work such as governments, politics, trade, and industry. Members of the council or members of the Majlis can represent all the rest in the local authority area. This is to make it easier for the public to deal with councillors or councillors to help solve the resident problems. Okay, continue. The next page. According to the United Nations Statistic Division of 2010, there have been increasement in the number of women participating in the paid labor force all around the world. From 1990 to 2010, it has been a steady 52%. The number of the female employees being employed has varied by country or region. For instance, women take up about 45% of the paid workforce in countries of the European Union, while on the other part of Northern Africa and Western Asia, women make up less than 30% of the paid workforce. In 2012, the report of the Organization for Economic Cooperation and Development, OECD, has stated that in its member countries, employment rates are 13% lower for women than for men. Occupations available to women are impacted by their race, class background, immigrant status, and marital status. Okay, next, it can be seen that there is still prejudice in terms of the employment for women, and although there have been some significant change, there are still a lot of change that have to be made to ensure the right of the woman in the work sector. Therefore, in the In these assignments, we will be discussing on the provisions in the Part 7 Employment of Women Act on how it affects in the workforce of the female employees. Okay, 2.0, Section 34, Prohibition of Night Work. Women employees are not being allowed to work on the night shift no matter what the situation are. The employer of the company has no right to force their female employees to work more hours throughout the night shift because according to the Section 34 Employment Act 1955, the Act protects the right for the working women in Malaysia from working at night. Employers are not allowed to require the women workers to work between 10 p.m. to 5 a.m. Neither can an employer require their women workers to commence work for the day without the worker have rest for a period of 11 consecutive hours for such work. However, this prohibition only applies to industrial and agriculture undertaking. Therefore, women can still work at night in sectors such as commerce, hospitality, public health, and entertainment. If the employer still want to do it, they may need to apply to the Director General of Labour for an exemption from this restriction, of which the Director General may allow which conditions. Okay, the point is no female employee referred to in regulation to shall commence work without having had a period of 11 consecutive hours free from such work, notwithstanding the provision of Section 34 of the Employment Act 1955 and the female employee employed in shift work in any approved industrial undertaking which operates at least 2 shifts per day may subject to regulative 3 work at such time within the hour of 10 o'clock in the evening and 5 o'clock in the morning, as the Minister may approve. For the purpose of this regulation, approved industrial undertaking means an industrial undertaking approved by the Minister to which the provisions of this regulation shall apply. Where a female employee is employed contrary to the provision of any of this regulation, the employers of such employee shall be guilty of an offence and shall be liable on conviction to a fine not exceeding 500 ringgit and in the case of a continuing offence, an additional fine of 50 ringgit for each day during which the offence continues. Okay, we can see figure show a female working alone at night after work. There is a situation when a woman working alone at night and it become dangerous to a female workers. Okay, employer of every company need to take this matter very seriously because there are already some cases in the past involving the female working in the night shift, and that is not good for the company's image, and also it will bring up the trust issue between the employee about their safety at workplace.
Assalamualaikum. Hi everyone, I'm ZATIL binti Karuna Syed. My student number is 2020729687. Thank you, my partner AFIFAH. Okay, 3.0 Section 35 Prohibitions of Underground Work. In the Part 7 of Employment of Women, it states in Section 35 that no female employees shall be employed in any underground work. In this context, underground works means all construction works that occur beneath the natural surface of the earth and within an enclosed space, said inside 2030. Even though the provisions is not ensure the protection over the female employees, this limiting the work employment for women in some aspects. It can be seen that underground works is dangerous and have a lot side effect for the female employees. The However, it can be said that the economic progress for the underground works is already increasing and benefiting the economic sector of the country. The current economic climate of Malaysia, where underground extractions of mineral is very rare, said Aminuddin at 2020. Therefore, this can be seen as an opportunity that needs to be grasped by the female employees. 4.0 Section 36 Prohibitions of Employment by Minister. The Employment Act provides exceptional protection for female workers. The Act does not require equal pay for equal work, nor does it outlaw discrimination against women. The provisions of the Act relating to women's mainly concerns work hours, prohibitions of women's employment by the minister, and monetary benefits. Then, here I will explain the prohibitions of employment by the minister. According to Section 36, Employment Act at 1955, prohibition of employment by the minister is about the notwithstanding the provisions of this part, the minister by order prohibits or permits the employment of female employees in such a circumstance or under such condition as may be described in such order. The section continues from sections 34 and section 35, which the prohibitions of night works and underground works. The government has the right to impose limitations on hiring women employees based on the preceding sections, section 34 and 35. Women are unique, creates, and such they are unable to perform certain tasks and must always to be protected because they are risk of the rape and sexual harassment. Women are not allowed to work after 10 p.m. according to section 34. They also that this curfew won't be effect of means because some of their jobs, like bus and taxi driver, can for them to work from dawn till dusk. Since women desire to treated similarly to men, some individuals may believe that the government is doing this out of gender discrimination. However, it was not, because we are already aware of numerous instances where women are put in danger quickly as a result of the government's implements of these rapes. Numbers are declining. There are 350 rape cases during 2019, but this climbs to 304 during 2020. This shows that there is a good effect after the government implements this. But the women still need to take care of themselves during the day as always, since we don't know when the bad thing will be happening. And the government must only give the curfew of the woman at night, but doesn't mean that all that will always be safe during the day. Section 38, Payment of Maternity Allowance. The maternity allowance described in a subsection 37 in a 2 and occurring in a each wage period under the female employee's contract of the service shall be paid in the same manner as if it were wages received during that wage period, as a given in a section 90, said the Commissioner of Law Revisions Act 2006. Pregnancy maternity leave or PML in the form a maternity allowance is advised to employees under the Employment Act OEA. The amount of a maternity allowance is determined by whether the employee is paid on a monthly or daily basis. When a female employee is paid on a monthly basis, she should be considered to have earned her maternity allowance if she is paid on a monthly basis during her maternity leave. A maternity allowance would be paid to a regular rate employee based on their employee's ordinary rates of pay for one day or a rate set by the minister, whichever is higher. The minister has set a rate at RM6 per day as the existing rates concerned have been reasons about the extent of the maternity benefits and the criteria that must be met in order for maternity allowance to be provided under the Employment Act (OEA). Next, Section 39 is a payment of allowance to nominee on death of a female employee. According to the legislation as amended on 1 April 2020, a female employee will be granted maternity protection if she delivers her child on week 24, which is equivalent to 6 months either dead or alive, said Muhammad at 2017. Referring to the act above, it stated that the nominee of the female employee is entitled to receive the payments of allowance. In Malaysia law, the current maternity leave entitlement is a 60 consecutive day. In addition of employee entitled to receive full pay of her wages throughout that a maternity leave period, which is from the day she begins her maternity leave until her death. This provision actually provided benefits for both employee and her department. This provision actually provided benefits for both employee and her dependents. The welfare of the desires dependent will be fully protected and taken whereby in the case an employee died due on a maternity, all the rights shall be transferred to her here. The rationality behind this act is not ensure the dependents will be able to continue their own survival. And last, in Section 42, restriction on dismissals of female employee after eligible periods. One, the Act that has been amended in the parts 9 of the maternity protections, it states in the Section 42 that a female employee will not be terminated from her job when she is on maternity leave unless the termination is due to the closure of the employer business. Furthermore, if a female employee remains absent from a work after the expiration of the eligible period due to an illness approved by registered practi- practitioner, the employer has no right to terminate her employment until her absence reaches 20 days. And the protections of the woman's worker from a dismissals on the grounds of the pregnancy and maternity lies at the core of a pregnancy and maternity protection. In conjunction with a international approaches on the issue, the 2000 Convention has extend the scope of pregnancy and maternity protection to cover both pregnancy and maternity. It is an offers for the employers to terminate the female's employee during the pregnancy, maternity leave, upon her return from a maternity leave, extend maternity leave and a while nursing, said but at 2050. Conclusion this issue, what can be concludes this report is women employees are protected in their workplace. Employment Act 1955 have said so and include 4 types of the session or providers that we have been discussed early in the report. The employer have no rights to force their employees to do something that behind of Employment Acts, such as working on the night shift and doing the underground works. The safety on the employees is the major priority for this report, and also it has been mentioned in every section in the Act. All the company involved need to take this matter very seriously and needs to ensure the safety of all their employees, especially the females, because their commitment is one to company needs throughout the work process, and the company needs to build trust with their employees. That's all. Thank you.